Okay, hello, John Dove here from the Advocacy Club, and we've just had the April session of the Legal Advocacy Club, and our members have been performing a bail application. So this is a piece of advocacy that is conducted fairly regularly by both barristers and solicitors in the magistrates and in the Crown Court. So what I'm going to do is just share some feedback and some sort of hints and tips on how to perform this piece of advocacy. So I'll start with some sort of general presentation tips and then move on to slightly more specific advice. So the first thing regarding presentation is that it's slightly different to other forms of advocacy that you might come across. So the typical thing I normally compare it to is mooting. So with mooting, obviously you have bundles that are prepared in advance and your judges would see bundles. Whereas with this, obviously this is a fictional scenario, but we've tried to make it as realistic as possible. And you can assume that your judges wouldn't have sort of a bundle there that you'll be referring them to and saying, I'm going to refer you to this page, I'm going to refer you to that page, etc. So you wouldn't have that sort of formulaic approach that you would do with other forms of more formal advocacy. And likewise, you wouldn't really have a skeleton argument and you wouldn't begin with an introduction, say, I'm going to address you on 3 points. You generally just sort of jump in with your main point, and I'll move on to that in more detail later on. In terms of the structure, it's very much a personal style. So, you could go into any sort of magistrate's court, watch a typical list, and you'd see 10 different styles in terms of the structure when it came to a bail application. So it's very much a personal approach in terms of the structure and the order in which you deal with things. A structure I quite like, though, would be as you're going through, look at the concerns as they've been raised by the prosecution. So obviously, in this case, you've seen three concerns that the prosecution have raised, and you might want to deal with those one by one by one. So that could be your structure. So you can say the first concern that my friend has raised is X, and then you deal with that concern. And I'll go into more detail later on as to how you deal with those. But that might be sort of a good structure there. As with anything, you need the general presentation point. So I say this week in and week out, but pace is massively important. Somebody like me with a Liverpool accent tends to speak quite quickly. So when you're in court, when you're in the scenario delivering this piece of advocacy, make sure that you slow down, bring your pace down to around 100 or so words a minute. It makes it easier to follow your argument and also makes you appear a lot more confident when you're speaking slowly. When you rush through at 5 million miles an hour, you don't appear as confident. So keeping it nice and slow is always massively important. The other thing as well is to avoid a script. Now, of course, generally in court, you probably wouldn't have much of a script anyway, because the chances are you'll have probably met your client a few minutes beforehand. You'll have jotted a few notes down, and then your advocacy will be based on the notes that you've made there. So you wouldn't really have time to be drafting out a full script. But of course, with this, you've had some time to prepare for it. And I'd say avoid a script or avoid reading from a script anyway, because when you read from a script, it's not quite as dynamic. It's a lot less conversational, and you don't quite have that rapport with your audience. So when you're there reading from a script, and even on Zoom, if you've got a Word document open and you're just reading from that, it's still quite obvious because you can see your eyes darting from left to right, and it's just not got that same level of rapport there. It's not quite as convincing and persuasive. So the idea is, even if you are going to work off a script, in a scenario like this where you've got some time, practice it a number of times in advance, so you at least got the basics in your head, and so you can perform in a much more dynamic fashion. And then the last thing I'm going to say on presentation is to try and keep the points quite simple. So quite often, we were talking about this earlier when we recorded a podcast episode. Quite often there can be a temptation to want to use sort of flowery and complex language when it's not really necessary. You don't always need to use 10 words when 5 will do. keep it simple, because A, it makes it easier for you to make the point, and secondly, it's easier for your tribunal to follow. So a simple point is generally an easier point to follow. So don't make it unnecessarily complex for yourself. Now, I'd mentioned about the fact that this piece of advocacy can be a lot less formulaic, and that even comes down to the law as well, because of course bail applications are governed by the Bail Act, but it's not like a piece of mooting where you'll be saying, I'm now going to refer you to section this, subsection that. As a general rule, most bail applications cover the same sort of points, and it's generally trite law. The judges, the magistrates, they're seeing these day in and day out. So you don't need to be saying, I'm going to refer you to section, whichever section of the act you might be going to. You can simply make your points. The judges know what the law is on this, so you don't need to be going through and citing in the same way that you would in a moot. At the beginning, I mentioned that the structure is quite open. I would still mention at the beginning what you're asking for. So whether you're asking for unconditional bail or whether you're asking for conditional bail, make that clear at the outset of your submissions. And now I've mentioned about dealing with the concerns that the prosecution may have. And I think with this case, there were three concerns, which were that the defendant might commit further offences whilst on bail, interfere with witnesses, and also breaches conditions. So they were the three concerns that were raised, and the Crown had reasons to raise those issues. So what you would want to do is, firstly, when you're dealing with each issue, deal with that concern and point out why that concern might not have merit. So of course, when it comes to the fact that they'll say, he won't, he'll fail to surrender, for example, there was a reason why he'd missed the previous hearing. It was simply an error in his diary. So you can point that out and say, well, that in reality, that's not really a concern. He's never missed any previous hearings. He's not going to miss any further hearings. So you can set that point out. But then secondly, if as a sort of layered approach, you can also say to the court, well, look, this is how we deal with the concern. This is why that concern has no merit. But at the same time, if the court is still concerned, here is an appropriate bail condition that can deal with that and hopefully allay any concerns that the court might have. As you're going through as well, as a general rule, try and deal with your strongest points first so that they're not sort of lost in the weeds later on in the argument. So deal with your strongest points as early as you can in the bail application. And then lastly, you might want to, in a quick sentence or two, just reiterate what it is that you're asking the court to do. It might be that you say, I'm asking for bail with the following package of conditions, just so it's there in the mind of the court again, right at the end of the submissions. So those are just some tips that I've got with regard to the bail application, and I hope you found that helpful.